So, good evening, aspirants. Welcome to Bajirao IAS Academy, the Hindu News Analysis. Today is 21st September 2024, and today we have some important articles for the discussion, and one by one we'll try to discuss all these important articles in a very detailed manner. But before discussing them, you all knew that yesterday there was a prelims practice question, and we'll try to understand this particular index and which organization or which agency releases this index. The question is, the Digital Payments Index is released by which of the following agencies or organizations? The options are Indian Banks Association, Reserve Bank of India, Niti Aayog, and the National Statistical Office. The correct answer for this question is Reserve Bank of India, because Reserve Bank of India releases the Digital Payments Index. So therefore the correct answer is option B. And if you look at the explanation for this particular question, so Reserve Bank of India RBI introduced this Digital Payments Index, which is also known as the DPI. So we all knew that India is one of the largest economies with a huge digitization across different levels, and even one of the biggest country in terms of the digital transactions. And in fact, the Reserve Bank of India has introduced this Digital Payments Index in the year 2021 January to measure the extent of digitization in payments across India. So with March 2018 as base year, and in fact March 2018 was taken as a base year for this particular digital payments. So this Reserve Bank of India and Digital Payment Index provides insights into the growth and also penetration of digital payments across the country. And in fact, so when we look into the calculation and parameters for this Digital Payments Index of the Reserve Bank of India, so this Reserve Bank of India Digital Payments Index is considered as a composite index, and this index is derived from 5 key parameters, and these five key parameters together contributing to the overall score of this particular Digital Payments Index of the RBI. And if you look at those 5 key parameters which are used for calculating this Digital Payments Index, they include payment performances, payment infrastructure supply side factors, payment infrastructure demand side factors, payment enablers, and also the consumer centricity. So these are the 5 key parameters which are being used to calculate the Digital Payments Index in India by Reserve Bank of India. And today also I have a very important prelims practice question, and in fact it was one of the in 2021 UPSC has asked this particular question in prelims examination. The question is, Central Groundwater Authority has been constituted under which of the following legislations? The options are option A, Environment Protection Act of 1986, Water Prevention Control of Pollution Act 1974, and Public Liability Insurance Act of 1991, and Hazardous Waste Handling and Management Act of 1989. So this is easy question, so try to answer this question in the comment section, and the correct answer I'll be providing you in tomorrow's class. So without any further delay, let's get into the discussion, because we have some important articles. So we'll try to discuss all these articles in a very detailed manner. So the first article is given in the the Indian Express newspaper, and this is very important from the perspective of General Studies paper 2, because judiciary as a topic which is given in General Studies paper 2, and even for prelims for that matter also, it is very important topic, right? Now, in fact, when we talk about the judicial appointments in India, so judicial appointments is a unique method in India, right? So unique method because the judges are appointed by the judges themselves. Judges are appointed by judges themselves, and this unique method of appointing judges is provided through the collegium system of the Supreme Court, right? So, or the judiciary has this collegium system, and collegium system usually make recommendations for the appointment of judges for the higher judiciary, including high courts as well as the Supreme Court, and at the same time the transfer of the judges of the both high court and the Supreme Court. So however, the cause of concern is that collegium is just a judicial innovation. It does not have the constitutional backing, and even it does not have any legislative backing, and that's how judiciary has been emphasizing that its independence, judicial independence is one of the key features. Judicial independence is one of the key features of the basic structure doctrine, and judicial independence can be adequately protected through the collegium system. So however, through 99th Constitutional Amendment Act, we all knew about this 99th Constitutional Amendment Act because previously also we have discussed. So the Parliament has provided for National Judicial Appointment Commission. So however, National Judicial Appointments Commission was declared as unconstitutional by the Supreme Court because it violates the independence of the judiciary. So because of this particular reason, the National Judicial Appointments Commission was declared as unconstitutional by the Supreme Court. So through collegium, Supreme Court cannot directly make appointments transfers to the higher judiciary. A collegium system recommend certain names or eligible judges names to be appointed as the judges of the Supreme Court or high courts, and these recommendations will be sent to the Union Executive, and then Union Executive will done a detailed scrutiny, detailed inquiry of the names suggested by the judiciary, and then Ministry of Law and Justice will forward those names to the President, and ultimately President would be the appointing authority, or judge, the President would be the ultimate authority to transfer judges of the Supreme Court, not judges of the judges of the High Court, but appointment of the judges of the Supreme Court and High Court. So however, as of now, the problem is that collegium system, even though recommending names to the executive, but the appointment has been stalled at the executive level, and that has created a huge vacancy, right? So it has resulted in a huge vacancies in the judiciary, and huge vacancies further resulting in the judicial pendency of the cases. And in fact, in India, judiciary enjoys enormous trust and confidence. There's a lot of public trust and confidence over the judiciary, but increasing pendency of the cases and increasing number of under trials, so all these problems have been plaguing the existing judiciary. So because of that reason, Supreme Court has demanded accountability on the part of the government with respect to the judicial appointments, and collegium, not search panel, give report on status of pending names. Supreme Court tells to the government or the executive, right? So I have explained in a very detailed manner the background of this particular order of the Supreme Court, or the Supreme Court asking the executive or the government with respect to the appointment of the judges, right? So Supreme Court has been pressing for or pressing the government for explanations regarding the delays in the judicial appointments. Now, why the government or the executive for that matter has been delaying appointments, even though collegium system has been regularly recommending names to the executive? So therefore, emphasizing on the importance of collegium system's recommendations in maintaining constitutional integrity and also the governance efficiency as well. And in fact, so when we talk about this collegium system and the recent Supreme Court's comments on the delay in appointments at the executive stage, even though the collegium system has been recommending names for the appointment as judges, and Supreme Court questioned the government about delays in appointing judges, so thereby stressing on or further emphasizing on the need for collegium's recommendations cannot be treated as a mere suggestions from the Supreme Court or the judiciary subjected to government discretion, right? So if you can understand whatever I have explained in the beginning of this particular article, so you can clearly understand this point, because as of now the government has been considering collegium system's recommendations regarding the appointments to the higher judiciary, judges appointment to the higher judiciary, as mere recommendations, and Supreme Court has been clearly giving directions to the executive that these recommendations should not be considered as suggestions alone, and the government should not act on discretion, on its own discretion, because that would further lead to the delay in appointments at the higher judiciary, and in fact it has been impacting the overall functioning of the judiciary. And that's how there is a tussle between the government and the judiciary with respect to the appointment of the judges, right? So Chief Justice D.Y. Chandrachud instructed the Attorney General to provide a tabulated report within 1 week detailing status of all pending collegium recommendations and the reasons for the delays on the part of the government. Because remember, as I have already told you, through the collegium system, the collegium system at the Supreme Court consists of the Chief Justice of India plus 4 more senior most judges of the Supreme Court. So this is the collegium system, and this collegium system consider names, and also those names would be forwarded or recommended to the executive to be appointed as the judges of the Supreme Court or High Court. But as of now, the government has not been taking any decision regarding the appointments to the higher judiciary, both Supreme Court and High Court, and that's why Supreme Court has asked the report from the government that within a 1 week there should be a report from the government about all pending recommendations or collegium recommendations, and even reasons for the delays on the part of the government. And in fact, Chief Justice D.Y. Chandrachud also emphasized that collegium has a constitutional status, and differentiating it from a search committee whose recommendations can be ignored. So as of now, collegium system is considered as a judicial innovation, but D.Y. Chandrachud, Chief Justice of India, says that, or emphasized that, this collegium system has a constitutional status, and also he differentiated it from the search committee whose recommendations can be ignored. So in case if it is a search committee, the recommendations can be easily ignored by the government, but this collegium system is not a search committee. And in fact, the Supreme Court has also noted that ignoring the repeated recommendations undermines the established judicial appointments conventions in India. And you can understand what is this collegium system. In India, the collegium system refers to the method of judges appointing the judges, and collegium system is based on the 3 judges case, the famous 3 judges case in India. And under this 3 judges case, appointment of judges are made by the Chief Justice of India and 4 most senior Supreme Court judges. Remember, I have already told you that these names which are recommended to the executive would be done by the Chief Justice of India and 4 most senior most judges of the Supreme Court. So therefore it has no constitutional backing, it is just a judicial innovation. But remember, Chief Justice of India D.Y. Chandrachud has emphasized that collegium has the constitutional status, but collegium is just a judicial innovation. And in fact, Indian Constitution Article 124 says that appointments to the both Supreme Court and High Court to be made by the President in consultation with the judges as President may deem necessary. So this is what Indian Constitution Article 124 says. And in fact, critics also says it is a closed door system which lacks transparency, and there is a need for transparency. And because of that reason, the 99th Constitutional Amendment Act has brought in by the government, which is the National Judicial Appointments Commission. However, Supreme Court has declared that this NJAC is unconstitutional in nature because it violates the independence of the judiciary. So you can also go through the details of the National Judicial Appointments Commission. Right. So in fact, what are the constitutional provisions regarding judicial appointments in India? So we'll try to understand the constitutional provisions specific to the judicial appointments. So there are 2 important articles in the Indian Constitution which deals with the appointment of the judges to the Supreme Court as well as High Courts in India. The first important article is Article 124 of the Indian Constitution, and Article 124 of the Indian Constitution deals with that the Supreme Court judges are being appointed by the President after President consulting with the relevant judges. So this is what the Article 124 of the Indian Constitution says, and in fact Indian Constitution or the constitutional framers not even preferred judges appointing judges in the name of protecting judicial independence, right? So Article 217 similar to Article 124, but the only difference is that so it deals with the appointment of the judges to the high courts, and in fact high court judges across different states or different high courts are being appointed by the President after consulting with the Chief Justice of India and state governor as well as the Chief Justice of the respective high court, and that is how the appointments of the high courts across the different states are being made. However, a lot of steps have been taken in the subsequent years to improve the judicial appointments in India. So we'll try to understand what are those steps which were taken to improve the judicial appointments. So remember that I already explained that the Union Parliament has brought in the 99th Constitutional Amendment Act in the year 2014, but this 99th Constitutional Amendment Act which has proposed the National Judicial Appointments Commission, and this National Judicial Appointments Commission tried to reform the existing process of appointing judges to the higher judiciary, but Supreme Court has declared the National Judicial Appointments Commission as unconstitutional because it violates the judicial independence, right? So this proposed National Judicial Appointments Commission to replace the collegium system, but after it was struck down for violating the judicial independence in India, and even there was a memorandum of a procedure as well, and it is also one of the way to improve the process of appointing or improve the method of appointing judges in India. And this memorandum of procedure was proposed in the year 1999, and in fact this memorandum of procedure outlines certain rules for appointing Supreme Court as well as High Court judges across different parts or different high courts in India. And in fact judges are being appointed, through a collegium, and this collegium system consists of Chief Justice of India and four senior most judges of the Supreme Court, and then these recommendations would be forwarded to the central government. So this is what is known as the memorandum of procedure apart from the National Judicial Appointments Commission. And there's also a revised memorandum of procedure that came into effect in the year 2015, and Supreme Court has directed a new memorandum of procedure for more transparency in the appointment of the judges, and it was finalized in the year 2017, but it was not yet adopted by the government. So that is why it has been delaying the appointment of the judges to both high courts and the Supreme Court, and that's the reason that the Supreme Court has been demanding more transparency and accountability in the appointment of the judges, so that could prevent the delay in the appointment of the judges to the higher judiciary. So I hope you have understood that particular article regarding the judicial appointments in India. And the next a very important article is with respect to White Revolution in India. So in fact, when I say White Revolution has revolutionized or substantially increased milk production, or even doubled the milk production in India, and in fact it has made India self-sufficient and self-reliant in milk production, and India is also exploring the opportunities of exporting the milk and milk products. So however, recently Home Minister Amit Shah has also came up with the idea of White Revolution 2.0 to further enhance milk production and further enhance the livelihood opportunities for the rural masses, especially women, right? So in fact this dairy farming has a lot of opportunities, or it provides a lot of livelihood opportunities for the people, and it also provides gainful employment opportunities as well in the rural areas, particularly the women entrepreneurs. So therefore, the union government has been planning to moot a new idea of White Revolution 2.0. So it is expected to further enhance the milk production in India, based on the success of the White Revolution 1.0. So we all knew about Verghese Kurian and also Operation Flood, and in fact Verghese Kurian was known as the father of White Revolution. And Operation Flood is part of the White Revolution, and it was launched way back in the year 1970, and it has ushered in the White Revolution, and it has also transformed the dairy sector in India, right? So because how it transformed dairy sector in India, cooperatives were formed in the dairy sector, and government started extending loans to these cooperatives, and the farmers started organizing themselves, and there is a proper supply chain network has been established connecting rural areas with the urban areas. So through all these ways, Operation Flood was a massive success which was launched in the year 1970. However, in order to give a further boost or further fillip to this dairy farming sector, the government has recently announced plans to launch a White Revolution 2.0 based on the success of the erstwhile White Revolution or Operation Flood. So we'll try to understand the details of White Revolution 2.0. So when we talk about White Revolution 2.0, so it specifically aims to boost milk procurement by the dairy cooperatives from the existing 660 lakh kg per day in the year 23-24 to around 1007 lakh kg by the year 28 and 29. And this is the first and most important objective of White Revolution. So thereby there will be adequate availability of milk to every section of Indian society, so thereby making it more and more available and affordable as well. And in fact we have a union Ministry of Cooperation at the central level, and this Ministry of Cooperation strategy will be specifically focusing on expanding the cooperative reach to new areas and also increasing their share in the organized dairy sector. So this is the objective of Ministry of Cooperation, and how the Ministry of Cooperation would ensure that this White Revolution 2.0 would be a massive success, right? So there will be a proper strategy, and this strategy would focus on expanding the existing cooperatives in the arena of the milk production, and these cooperatives would also reach or penetrate new areas and also increase their share in the organized or formal dairy sector in India, and all sorts of assistance, finance, technology, or even expertise, skills, training, everything can be provided by this particular ministry to the cooperative societies and the individual farmers. The White Revolution 2.0 will further increase procurement of dairy cooperatives by around 50% over the next 5 years. So this is another most important objective of launching White Revolution 2.0, and it will do so by providing market access to the dairy farmers, because remember that not just having dairy farmers across different parts of India would be sufficient, would be inadequate. Rather, these farmers should have a ready market access, and that is how these incentives can be readily transferred to the farmers, so thereby providing market access to the dairy farmers in uncovered areas and also increasing the share of dairy cooperatives in the organized sector would be the need of the hour. And even the National Program for the Dairy Development 2.0 will provide the bulk of funding for the White Revolution 2.0, and the scheme will also offer financial aid to set up milk procurement systems, chilling facilities, capacity building programs at the village level. So all these things are aims and objectives of White Revolution 2.0 or Revolution 2.0. Now we have discussed what is white revolution, what are the aims and what are the objectives of this white revolution that the government has been planning to launch. But we have to understand what is the need for white revolution 2.0 specifically. Now when we look into this, why there is a need to have a white revolution 2.0, so there is a need to substantially enhance the productivity through advanced techniques, advanced technologies, providing more training, more assistance, financial assistance, or all sorts of assistance for increased milk production in India. And apart from that, whatever cooperatives we have, whatever dairy farmers we have, ensuring market access is very, very important. And in this context, we need to further expand the market access. So in order to do so, we need to connect the rural producers with the broader markets. And sustainability of this white revolution agenda, or sustainability of dairy farming, and the sustainability of existing cooperative societies who are engaged in the dairy farming is also very, very important. So therefore the focus will be on organic, eco-friendly practices in the dairy farming. However, there are certain challenges that we have to look into to ensure the successful or success of white revolution 2.4. and when we look into those challenges, rising inflation, where all cannot afford the milk and milk products due to rising inflation, and reduced demand for the milk products is one other reason, and increased competition from other countries such as Australia and New Zealand into the Indian markets, and increased production costs of dairy farmers. And these cooperative societies which are part of this dairy farming or this white revolution are not properly organized, and even the consumer affordability concerns are certain challenges that we have to look into. However, there were several steps taken by the government to ensure that there is a sustainable implementation of the dairy farming as a sector, and that would further give fillip to the white revolution 2.4. so initiatives including Rashtriya Gokul Mission, e-Pashuhat, Pashu Sanjeevani, National Animal Disease Control Program to promote milk production and also support farmers across India. Right. So the next important article is with respect to High Court's fact check unit order. So we'll understand this in a very detailed manner. What exactly is this fact check unit order? Right. So this is essentially a tussle between the government and the freedom of speech and expression of Article 19 of the Indian Constitution, because freedom of speech and expression is one of the fundamental rights, and it is very important for any democracy. So however, through government through this fact check unit, so there were fears that the government tries to curb arbitrarily impose restrictions on individuals' freedom of speech and expression under Article 19 of the India's Constitution. So therefore, in this context, what is the response of High Court regarding the fact check unit of the government? Right. So Bombay High Court has struck down a key provision of the amended Information Technology or IT Rules 2021 under the IT Act 2000. And in fact, the Bombay High Court has held that the the amended IT rules of 2021 were unconstitutional. Now, why Bombay High Court declared these amended IT rules unconstitutional, we'll look into that in the next next part of this lecture. However, this provision has empowered the government to identify fake news. The amended provisions of this IT Act or IT rules of 2021 has amended the government to identify fake news and also act on those fake news within the social media platforms through establishing a fact check unit. Right. So the government has also established a fact check unit, and the fact check unit is the Press Information Bureau. And in fact, so the government would identify the fake news through this amended IT rules, and government has also established the fact check unit through these Information Technology Rules of 2021, which is the amended form of IT Act of 2000. However, so if you look into the details of this IT rules, so we'll go into the backdrop and we'll try to understand the context, and then we could understand this very, very clearly. So Ministry of Electronics and Information Technology in the year 2021 formulated IT rules, right? So these IT rules were known as Intermediary Guidelines and Digital Media Ethics Code amended rules 2023, right? So initially these IT rules were brought in the year 2021, and again these rules of 2021 were further amended in the year 2023, framed new rules, and these 2023 new IT rules have provided or empowered the government to identify fake news. And in order to identify fake news in these social media platforms, the IT rules empower the government to establish fact check unit, and government has also established the Press Information Bureau as the fact check unit. And in fact, if any intermediary such as Facebook, WhatsApp, Twitter, or any of these social media platforms, or they are also known as intermediary platforms, host these fake news, and if government notifies those intermediaries to remove such news from remove such content from their platforms, if they don't remove such content from their platforms, they would remove the safeguard mechanism, right? So they would they would be stripped of this safeguard mechanism which protects these intermediary platforms from the third party information, right? So when the government removes the safeguard mechanisms, these intermediary platforms such as Facebook, WhatsApp, Twitter, or any other social media platform would be responsible for this hosting fake news, right? And appropriate legal action would also be initiated against those intermediaries, and that is what the new rules have been saying, and that is what we will be understanding in this part. So it also expanded the general term of fake news to include the government business as well, and apart from that, it has also defined the powers of the fact check unit. And remember, PIB was given powers as a fact check unit, and fact check unit comes across or is informed about any posts that are fake, false, and even contain the misleading facts pertaining to the government. And in fact, this fact check unit as per the IT rules of 2023 would also flag it to the social media intermediaries concerned. Remember, so try to understand. I'll explain this. For example, a social media platform X, and there's a person called A, and this person has posted a certain information in the social media platform X. So as per IT rules, amended IT rules 2023 and 2021, what the government has done? So government has decided to further broaden the definition of fake news, and in order to identify fake news posted across different social media platforms, government has established a fact check unit. And if this fact check unit finds that the information or the post on social media platform X is fake news against the government, then government would ask the intermediary or this particular platform X to remove this content because it is fake news, false news, and even it also contains misleading facts against the government. So if this platform X does not remove the content posted by A, then this intermediary platform would lose its safeguard mechanism, and this intermediary platform X would be legally liable for action for hosting this fake information or misinformation against government, right? So that is the concern of these social media platforms. But on the other hand, person A says that how can government or this intermediary platform would remove my content, and it is against Article 19 of the Indian Constitution, which provides or which gives him the right of freedom of speech and expression. So that is the cause of conflict, and that is why Bombay High Court has in fact declared that these IT rules of 2023 and 2021 were unconstitutional in nature. And in fact, the constitutional validity of these IT rules 2023 was challenged in the Bombay High Court. So on the basis of them being arbitrary, unconstitutional, and they are also in violation of the fundamental rights which are provided by the Indian Constitution. Now, what was the response of the central government regarding in the Bombay High Court? And central government has said that the rules were not against any opinion, a criticism, satire or humor targeting the government. This is what the center's response. And in fact, the center has also said that those information which the fact check unit identifies as misinformation or fake information meant to only prohibit the fake news, false news and even misleading facts on social media related to the government business. However, the center has also notified the fact check unit under the Press Information Bureau. Remember, this I have already explained to you. However, the Supreme Court has stayed operation of the notification under IT rules of 2023 until Bombay High Court took a final decision on the petitions challenging these amended rules, right? So this is what the center has said, and you could also go through this and what are the key developments so far in this particular judgment of the Bombay High Court. And what was the judgment that was given by the Bombay High Court? So if you look at the judgment given by the Bombay High Court, so it said that it is a violation of the fundamental rights. The amended rules of IT, the IT rules 3 and clause 1, subclause B and also subclause V was violative of Article 14, which is equality before law, and also Article 19 clause 1 and clause A, freedom of speech and expression, and also Article 19 clause 1 and subclause G, right to practice a profession or trade of the Constitution. And in fact, the verdict by the Bombay High Court also held that the IT rule curtailed the fundamental rights of citizens beyond the reasonable restrictions prescribed under Article 19 clause 2, so which was impermissible through the mode of delegated legislation, and also using a vague expressions. The expressions which are considered as fake, false or even misleading, and the rules are vague and under the right to freedom of speech and expression, and there is no further right to the truth. Okay, so apart from that, the inadequate safeguards, the center claimed that the decisions given by the fact check unit can be challenged before a constitutional court and they cannot be treated as adequate safeguards. And these are the observations of the Bombay High Court when it declared the amended IT rules as unconstitutional, or they are violative of Article 14 as well as Article 19 clause 1 and clause A of the Indian Constitution, right? So you could also go through these details in a more detailed manner if you want. So the next important article is about science and technology, and we all knew about Elon Musk Starlink satellites, and these Starlink satellite belong to SpaceX, Elon Musk's company, and Starlink satellites will provide broadband or internet services to the remote areas across the world. And in fact, a recent finding has came to the light that the Starlink satellites, a constellation of a number of satellites, disrupts astronomy. We'll try to understand this in a very detailed manner. And new research has revealed that Starlink satellites have been creating a significant radio noise, and this significant radio noise has been impairing the astronomical observations and also sparking urgent discussions about the need for regulatory measures on the satellite emissions. right? So this is what the new research has revealed about the Starlink satellites, because they are creating radio noises and they are also impacting the astronomical observations, and they are also sparking different discussions about the need for regulatory measures on these satellite emissions, because that could impact the astronomy, and astronomy is very important at the global scale. And so when we talk about the Starlink as a project, so it was launched by SpaceX, and its objective is to build a low-cost satellite-based broadband network for global internet access. And in fact, this Starlink is positioned between 350 kilometers and 1200 kilometers in the low Earth orbit, and key benefits of the Starlink satellites include reduced latency in data transmission due to proximity to the Earth. So these are some basic details of the Starlink project, but you have to understand what is the Starlink project and which company has launched this Starlink project, and what is the aim and objective of this Starlink project. And so what is the impact of Starlink satellites on the astronomy, right? So we'll try to understand what is the impact of this satellite on astronomy. So a study by Astronomy and Astrophysics has reveals that Elon Musk's Starlink satellites are disrupting astronomers, and they're not just disrupting the astronomers' work, they are also releasing the unintended electromagnetic radiation, which is also known as UMER, right? So how it has been disrupting the Starlink constellation of satellites have been disrupting the work of the astronomers through they are creating unintended electromagnetic radiation. However, 6,300 satellites currently orbit Earth at approximately 550 kilometers, right? So this constellation of Starlink satellites includes 6,300. So you can imagine the quantum of satellites as part of the Starlink project, and they are currently orbiting Earth approximately 550 kilometers, thereby providing access to remote areas but generating significant radio noise, and this radio noise has been impacting the radio astronomy, or it has even hampering the radio astronomy. So because of the creation of this unintended electromagnetic radiation, there is a call for regulation of such satellite services or satellite emissions. So Starlink satellites of SpaceX company emit the unintended electromagnetic radiation 32 times brighter than their predecessors which were in space. So therefore, Starlink satellites have been raising alarm, as the satellite count could reach 1 lakh even over a period of time. And even experts have been advocating for regulations on satellite emissions similar to those in place for ground-based electronic sources as well, thereby emphasizing on importance of minimizing radio pollution on the ground, and also reducing the unintended electromagnetic radiation in the space also, because the unintended electromagnetic radiation in space has been clearly impacting the astronomy activities. So currently astronomers are relying on cooperation with satellite companies to address these issues. However, the call for regulation is the need of the hour to ensure that these satellites don't emit too much of electromagnetic radiation, and that would not impact the astronomical activities of humans, right? So that's all in this lecture, and thank you so much. So if you like our work, please subscribe our YouTube channel and also hit the like button. Thank you.